record should reflect that Mr. Adams is present here in the courtroom today. If I could have counsel for your appearances on.
Sierra Coca, behalf of the people.
Thank you, Your Honor. Jason Thompson, on behalf of defendant Richard Adams.
This is the date and time set for a sentencing hearing in this matter. Mr. Adams, did you have an opportunity to go through the pre-sentence report and talk to you?
Yes, I did.
Okay. I do want to note for the record that I did have a discussion about this filing chambers with your attorney, the prosecutor, and the probation officer about some matters that I think we've all agreed won't put on the record, but you're aware of that conversation, Mr.
Yes, sir.
Mr. Thompson, are there any additions, deletions, or corrections that need to be made?
No, Your Honor.
Are there any challenges to the scoring?
No challenges to the scoring.
Ms. Pope, do the people have any additions,
No, Your Honor.
challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocation?
Your Honor, my main concern with Mr. Wakely is not his criminal history, which at 58 only has 1 felony and 2 misdemeanors, but that he's had some struggles appearing for court. He's absconded for some time. I mean, we didn't charge him with that, but he probably could have been charged with it if a report had been submitted. There was not one. He has been subpoenaed to a proceeding in the middle of February. We've just had problems dealing with him throughout his case. The recommendation is 90 days with 47 days credit. I talked to MDOC about whether or not it'd be appropriate to put him on a tether, given that his absconding previously to allow him to get out. It's unclear to me where he's going to reside when he leaves, so whether or not that's appropriate. I think the recommendation is appropriate. I think 120 days would also be appropriate, given that he's absconded. Thank you.
Thank you, Mr. Thompson.
Thank you, Your Honor. Court's reviewed the PSI. The court knows that Mr. Adams was dealing with methamphetamine addiction, horrible, highly addictive substance. The court's aware that he was forthright with law enforcement, a very cooperative person, in my interactions with him, very helpful. I understand that there was the period where he was not available. I understand that's obviously a concern for the court. Mr. Adams is doing the best he can. He is trying to focus on remaining drug-free and finding employment and not having those bad associations. He does have his longtime girlfriend who's here today with him, who's a support person for him. I think he can address his living plans when he's released. I didn't know that was going to be so much of an issue today, but Mr. Adams is hoping to do his time and to be released. He would ask the court to consider time served on this. I think the court's aware of his facts and circumstances, but he can address what his plan is for when he's released, where he's going to reside.
All right, thank you, Mr. Adams. Anything you'd like?
No, sir.
So, Mr. Adams, I did have a chance to review the pre-sentence report, so I'm familiar with certain cases and reasons for the report here today. There's also a lot of information in that report about you, your background,
Right.
history, and so forth. So, I've got all of that information. As I indicated, I did have a discussion with counsel about another mitigating factor in chambers. So, be fully aware of all the circumstances involved in the case. There's some things that work in your favor here, certainly. Lack of a significant criminal history. There's been a significant period of time, between your previous convictions and now. The circumstances of this case involved a small amount of methamphetamine, a personal use amount. There's no indication that you were trafficking in part of this. So all of those things are things that help you, of course, in complicated matters. Your behavior that makes this more of a serious issue than maybe it could have or should have been addressed differently. All in all, I think the recommendation is appropriate. I think it's a fair recommendation. I think it takes into account things that work work in your favor and the things that don't. The guidelines here call for a sentence of up to 9 months. The lower third, again, it takes into account all the factors. It also provides for probation, which I think is important. So I'm going to follow the terms of the recommendation to the extent that you're released prior to or subpoena to testify in another matter. I will approve the use of a tether if that's available.
Right.
If it's not, then it's not. Cross that bridge when we come to it. But in terms of the sentence, I don't find that circumstance can be a reason to give you a more lengthy or more lengthy sentence. That's something that really is not a consideration that I can address through sentencing, other than to say that I think the tether would be appropriate. Yes, sir. So I'm going to file the recommendation, sentence you to a period of probation for 24 months. The court is going to adopt as the conditions of that probation all terms and conditions listed in the report. The court is going to order that you serve 90 days in the Crawford County Jail. You have credit for 47 days served. If there is a tether available, the court will order that the tether be made part of the conditions of your probation up and until the time of your testifying or your subpoena, other matter. The court is going to order a crime victim's assessment of $130, court costs of $325, attorney fees of $350, $68 state costs, and $30 per month for supervision while you're on probation. The court is going to order that the probation be served for 2 years. You have the ability to seek an appeal of this sentence. And
Mr. Adams, this is the notice of your, by initialing this one, you're indicating you've received it. If you wish to file an appeal, yep. Initials fine. If you wish to file an appeal, you would fill these out and submit them to the address contained on them. You can kite them if you don't have postage. So these will go back. By the time you're released, so you get good time. So you get 1 day for every 5 days you've been in. So I got you getting out like 20 some days.
okay. Good luck to you going forward. Yeah.
You can go back with Steve.
Thank you.
Record in People versus Steven Gilner, file number 255450 and 265515.
Sierra Cook.
Reflect Mr. Gilner present here in the court today.
Sierra Cook on behalf of the people.
Thank you, Your Honor. Jason Thompson on behalf of Steve Gilner. Your Honor, we have trial set for Monday. The prosecutors made a new plea offer. It's my understanding Mr. Gilner wishes to accept it. He would ask the court to plead no contest on the basis of having ingested some substances that day that affected his memory. The plea would be to an added count 3, which is 3rd-degree arson, as well as a guilty plea to count 2, which is threatening a witness. Those are both 10-year maximums. I have scored that with Mr. Gilner and discussed it with him. In exchange, the prosecutor would dismiss the count 1 arson, 2nd degree, which is a potential life offense, and she would also dismiss the separate bringing contraband to a jail case.
Okay. Let's go.
That's a correct statement of the offer.
Mr. Gilner, have you had a chance to talk to Mr. Thompson about this agreement?
Yes, sir.
Is that how you wanted to proceed today?
Yes, sir.
Can you raise your right hand, please? Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. Lower your hand. Mr. Gilner, are you currently on any kind of probation or parole?
No, sir.
All right. And as Mr. Thompson indicated, the maximum possible penalty that you could face for each of these charges would be up to 10 years. Do you understand that?
Yes, sir.
With that in mind, what is your plea to those charges today?
Clothing.
No contest?
Yeah.
Okay. All right. Right now you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. Do you understand all those rights?
Yes, sir.
And do you understand that you're going to be giving up and waiving all of those rights by pleading no contest?
Yes, sir.
Has anybody threatened you with anything to get you to do that?
No, sir.
Has anybody promised you anything other than what we've said here in court today?
No, sir.
Is it your own free choice to enter this plea?
Yes, sir.
All right. So first of all, I have reviewed the police report. Based on the information, I do find that a no contest plea would be appropriate based on intoxication. And I'm referring to Michigan State Police Report number 213-25. Ms. Koch, have you reviewed that police report?
I have.
Do you agree that the information contained within that report would provide a factual basis for the added count of arson third degree and count 2?
Yes.
Mr. Thompson, have you reviewed that report?
I have.
Would you agree that it provides a factual basis?
I do. I also agree it provides a factual basis for the no contest to be based on intoxication.
All right, the court's going to mark and admit that report as a court exhibit 1. Ms. Koch, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No.
Mr. Thompson?
No.
Ms. Koch, are the people satisfied that the court has complied with statute and court rule in the taking of this no contest?
Yes, Your Honor.
Mr. Thompson?
Yes.
All right, Mr. Gilner, the court finds that your plea is knowing and voluntary. The court is satisfied based on the information contained within Court Exhibit 1 that there is a factual basis to support a finding that you are guilty of both the charges in this case. The court will accept your no contest plea. We'll set this matter for a sentencing hearing. Between now and then, you're going to meet with someone from probation for a pre-sentence report. You'll have a chance to go through that with your lawyer prior to that sentencing hearing. Do you have any questions at all?
No, sir.
Okay. In light of the plea today, we'll adjourn the trial set for Monday. And that's all for today.
Thank you, sir.
You want
Mr. Trush, are you able to hear me okay?
Yes, Your Honor.
All right, we're on the record now in People versus Joseph Poyer, file number 2554171. The record should reflect Mr. Poyer is present here before the court today. I'd like to have counsel put your appearances on.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Richard Fuchs on behalf of Mr. Poyer.
Thank you. We're on the record today. We did have a hearing previously scheduled in November. Mr. Poyer failed to appear for that hearing. The court issued a bench warrant. He was apprehended on that bench warrant in late December. and has been lodged since that time. The court set this for a status conference today to address that as well as any bond going forward. Mr. Trush, can you tell me the status of this file here today?
So, Your Honor, I've had discussions with Mr. Poyer about this file. Unfortunately, I mean, he hasn't made his intentions on how he wants to proceed completely clear. I've discussed with him what the offer is. And I mean, what he repeatedly will tell me is that what he wants to do is get mental health treatment and get treatment for his mental health, which frankly, I think is a good idea. I think that is something that he needs to address, and I think it's something that permeates the case. However, it doesn't completely answer the question of how does he want to address the matter. I certainly think that there are options in terms of mental health treatment that can have an impact on how the case goes. I've discussed with him things like mental health treatment courts. I've discussed with him things like, jail diversion programs through CMH. But I'm not sure that we're zeroed in and completely dialed in on how it is that we want to, resolve the case ultimately. In terms of bond, I would suggest to the court, Mr. Poyer has been in contact with me in my office consistently. He expressed to me, he suffers from a variety of different mental health issues. He's given me psychological evaluations that he's had done in the past, which outlines some of these issues, and expressed to me concerns, about the hearing, expressing to me that he has agoraphobia. In fairness and in candor to the court, I don't have a specific diagnosis of that yet, and I don't know if there is one out there. But again, he certainly is diagnosed with anxiety disorders, and a variety of other maladies. So it would not surprise me, but again, I can't in good conscience tell the court I have a diagnosis of agoraphobia at this point. So I guess in terms of a bond, I would ask the court to set a bond that he would be able to post. Because again, I do think that the mental health issues are permeating the case. And again, he has not violated any of his bond conditions again, other than the missed court appearance, which frankly, I mean, Zoom might be a middle ground that would allow him to maintain those appearances. Thank you.
All right. What is the current plea offer, Mr. Trush?
Your Honor,
The offer is domestic violence, third offense, dismiss his habituals.
and count two.
Okay, yeah. As well as I think we offered he has a misdemeanor case in district court. I think we offered to dismiss that as well.
All right, so Mr. Poyer, we have to figure out how we're going to go forward with your case first. And there's two options. You can either go forward with a plea agreement, or we can have this set for trial. But we need to determine the outcome of the case before I can address, if you're eventually found guilty either through plea or by a jury, then I'd be more than happy to consider, treatment and those types of things as an option for sentencing. But until we get to that point, there's not much that we're going to do in that regard. So we need to know from you how you want to proceed with your case.
I don't know what to do right now. I need my medication so I can even think straight. Like I'm off balance right now. Like I don't even know what's really going on. Like I just confused. I don't know. I need my medication. They won't give it to me.
Can you tell me what you're confused about?
Just everything. Like my mind just feel like I'm suffocating right now. And it's hard to process anything. I can't watch TV. I can't read. I can't do much of anything.
Okay. Mr. Trush, when was the last time you had a chance to speak with Mr. Poyer?
I had an opportunity to speak to him.
Like recently, within the last
Yeah,
week or
I
two?
think it was. I think it was Tuesday night. And in candor, that was the first time I was aware that this was up this week. That was when I received the notice of the hearing.
Sure.
And again, I spoke to him that evening and talked to him a little bit about what the hearing was about.
During that conversation, which I'm sure is more extensive than what I've had with Mr. Poyer here in the courtroom, did that raise any concerns to you about competency? I mean, what he's indicating to me on the record is that he's having trouble understanding what's going on, not just within this case, but generally.
I haven't had concerns with competency. When I talked to him about the case, I mean, he expresses to me, reasonable ideas in terms of how to defend the case at a trial. He expresses to me and understands the difference between a plea and a trial. So I mean, candidly, my worry is I think a competency eval probably isn't going to do us a lot of good.
Okay. All right. So, Mr. Poyer, you can either plead guilty and admit guilt as to the charges under the plea agreement, or we can have this set for a trial. And if you don't know what you want to do, what my intention would be is to have this set for a trial, and then you would have time to still enter a plea after that.
All this is just me being unstable. It's not me to have any of this anymore. I don't know what to do.
Okay, so I'm gonna go ahead and put this on the trial docket and set it with a plea cutoff. Ms. Cope, how much time do you need to be ready for a trial?
Because he is lodged, he's probably going to take priority. I would say we can be ready in 60 days. Our February dockets are really full. I think we have 9 felony jury trials scheduled in February. So we would ask for March or April. I will say for the record, just so the court's aware, he did fail to appear in his misdemeanor case as well. His parents indicated he had stopped his mental health treatment prior to being arrested and prior to the incident. And he has a pretty long criminal history. So if we're going to talk about bond, I'd like a chance to address that. Thank you.
Yeah, we're gonna talk about that in just a second. Mr. Trush, if we set this for March or April, is that enough time for you to be prepared?
Yes, Your Honor.
Okay, and Ms. Cope, how many days of trial?
I would say we could do it in one. If defense is gonna call witnesses, we may need 2. I will probably do a 768 and 404B notice.
Mr. Trush, I'm gonna go ahead and set this for 2 days, just in case we do need extra time for picking a jury, and so forth. And then the court will set this for a final status conference and plea cutoff prior to the trial date.
Could we also have a status conference next month? Just because of what Mr. Poyer said today. I don't want to have it. I mean, that'll be February. We may need 2 status conferences, but I think that'd be better in this case.
Yes. Do you have any objection to that, Mr. Trush?
No, Your Honor. My intentions was to indicate to the court. I will go over and talk to Mr. Poyer. If there is movement or a change in something, I would notify the court. So I'm fine with setting a status conference.
All right, thank you. All right, and then Mr. Trush, was there anything else you wanted to say regarding bond?
No, Your Honor.
Ms. Cope?
Your Honor, Mr. Poyer, and we went over this a couple of different times, has a pretty extensive violent criminal history. Some of it's missing from his CCH, but I was able to put it together through his prior PSIs. But he has a 2001 MDOP, that was a juvenile, a CSC 4 juvenile, a larceny juvenile. In 2002, he has a UDAA. In 2002, he has a flee and elude third. In 2002, he has a UDAA. He did have a domestic violence in 2004 that was dismissed, but he had a conviction for domestic violence and cutting telephone lines, it looks like. In 2006, he had an MDOB less than 200. In 2006, he had an OWI. In 2013, he had another domestic violence. In 2013, he had aggravated stalking. In 2014, he had a malicious destruction of a building less than 200. In 2017, it looks like it was an assault by strangulation in DV2. It's a little confusing from his CCH, but it looks like he went to prison on this. His parents believe that this was the case that he went to prison for 5 years on. And that same year, he had an R&O. Looks like the sentencings were similar in date. And that's his parents had called me when this case started repeatedly. They indicated they were in fear for their life and thought that he would kill them. When he got out, he went right to their house, and I ended up talking to the bondsman. State trooper was present as well. He was getting, I think, his camper or things from his camper. I don't remember how that played out exactly, but he was there immediately upon being released. They were concerned about that. And then, he failed to appear in this case, indicated he wasn't coming because he was agoraphobic. And then in his illegal entry, he indicated the same and didn't appear for that. So I'm not sure if we release him on bond that he's going to appear again. His criminal history, as I said, is pretty violent. And the victims in this case were pretty adamant that they were concerned. He had mental health treatment, but he stopped going to it on his own prior to the incident, according to his parents, who were the victims. Thank you.
Mr. Poyer, was there anything you wanted to say regarding bond?
Yeah, I'm not a violent person.
All right, given your past history, Mr. Poyer, given your failures to appear in this case and your district court case, court finds that cash or surety bond in an amount greater than your previous bond is necessary both for public safety purposes and to ensure your appearance in court. Court will set bond in the amount of $50,000 cash or surety. Court will adopt all the conditions of your earlier bond, which included no contact with Donald or Lori Poyer. So the court will continue those conditions as well. And then the next hearing date will be in February. You'll be notified of the date and time of that hearing, and you'll have an opportunity to speak with your attorney prior to that. Mr. Trush, anything else we can address for the record today on this case?
No, Your Honor, thank you.
Ms. Coe?
No, thank you.
Thank you. That's all for today, Mr. Poyer.